What are the provisions of California's Public Records Act that are applicable to the governor? In California's government code, it provides for access to public records, which the procedures are set forth in California's PRA, the Public Records Act. It's in Division 10 of Title 1 of the California Government Code. And as you can imagine, there are specific types of public records as well as applicable employees and officials. Article 1 of Chapter 14 of Part 5 of Division 10 of Title 1 deals with the governor's office, and Government Code Section 7928.000 provides that, with a few exceptions, the PRA does not require the disclosure of correspondence of the governor's office or to the governor's office or employees in the governor's office, as well as documents that are in the custody of or maintained by the governor's legal affairs secretary. Now, the PRA does say that public records can't simply be transferred to the custody of the governor's legal affairs secretary in order to evade disclosure under the Public Records Act. Now, Section 7928.005 says that when the governor leaves office, that public records go into the custody that are in the custody of the governor are to be transferred to the California Secretary of State, who oversees the state archives. And that's to be done as soon as practical. Now, the governor may place in writing, and issue publicly certain restrictions for public access to those transferred public records or other writings of the governor. Now, public access cannot be restricted for more than 50 years or the death of a governor, whichever is later. Also, there can't be any restrictions whatsoever on enrolled bill files, press releases, speech files, or writings related to applications for clemency or extradition for any cases that have been closed for a period of at least 25 years. Also, there are provisions related to governors who held office between 1974 and 1988, and basically says that these types of limitations don't apply to the records and writings that were under the governor's custody or control when they left office in those years, and says that the governor may voluntarily transfer those records to the state archives or can be transferred to an educational or research institution here in the state of California. Now, any institution that receives those records or writings has to allow the Secretary of State to copy at state expense and make available to the public any of these records or inventories or other materials. And so otherwise, those are the provisions of the PRA as they apply to governor's office records.